The former prep school student who was acquitted of rape but convicted of lesser charges of sexual assault last year is seeking a new trial. He's appointed a new lawyer who has filed for a motion for a new trial. Owen Labrie was sentenced to 1 year in jail but was free on bail as he appeals his case. But after violating terms of release, he was sent to jail last month. Here with me now is CBS News legal analyst Rikki Klieman and Jay Rancourt, Owen Labrie's new attorney. Thanks for being here. Appreciate it.
Thank you for having me.
So, Jay, how will you argue that Owen Labrie has received inadequate counsel?
We're arguing that the performance at trial was constitutionally deficient in a number of ways. First, failure to challenge the computer offense, the felony computer offense, pre-trial, at trial, and then in requesting an appropriate jury instruction. And then we're also arguing that certain deficiencies occurred at trial as far as challenging the credibility of trial witnesses, challenging the credibility of the complaining witness, failure to request some social media records of the complaining witness, and then failing to object to what we believe was a misstatement of evidence in the closing argument.
Jay, if I can go back to the first point, which I think is really an interesting point of law in this case. The computer charge is really a charge of using, could be your mobile device, could be your desktop, your laptop, and asking her out. But the charge is that he had to intend to sexually entice her, I assume, for sexual intercourse. Is that right?
Right. The jury instruction that was given to the jury was that the intent in sending the email had to be for purposes of engaging in sexual penetration with her.
And in this particular case, one of the arguments that's been made to our people like our viewers is that if he had just used the phone, that then it would have been okay, but because he used a computer, that it wasn't okay.
That's accurate. Under the statute, that's accurate. But, you know, our contention all along has been that statute was created for different purposes. The statute was created for older men trolling the internet for young girls.
And when you have a situation like this, one of the issues is, although he's convicted of statutory rape, that is not forcible rape, where it's a misdemeanor. So what is really the difference with his then being convicted of a felony of using his computer?
The big difference for the felony conviction is he's required to register for life as a sex offender now because of that felony conviction, whereas under the misdemeanor sexual assault statute, the legislature saw wisely so to say, if you're convicted of this as a misdemeanor because your ages are so close, you don't need to register at all. Because we don't want to tag someone as a lifetime registrant as a sex offender for teenagers having consensual sex. But then because of using the computer rather than text or a phone call, now you're a lifetime sex offender.
Jay, let me just ask, how is he doing? How's life in jail for him?
You know, he's doing the best he can. He's holding up. The problem for Owen is he's not just in jail. He's in what most people would refer to as solitary confinement. For most of the time he's been there, he's been in a cell 23 hours a day. Now he's getting out a little bit more, but it's really rough.
When one of the gifts that Owen Labrie got, and there weren't many in this case, when he was allowed to not have to go into jail pending his appeal, that then the judge finds that he violated his conditions and now he's in. Tell us what happened.
Well, you know, I guess there's a divergence of views on that. What we contend happened is he was supervised by an agency called the Pretrial Services, Merrimack County Pretrial Services. They had authorized him to breach curfew on a few of those occasions, to visit lawyers for other purposes. The state took the position that they weren't authorized to authorize him to be out after curfew. On 3 of those occasions, he had left early in the morning to travel to Boston to meet with college professors and go to the library. And we had argued to the judge, you know, that was a violation, but that under the statute there's a second component of clear and convincing evidence that no conditions of bail could be complied with. And we said, just give us some leniency here so that he can live a life outside of the confines of his house.
In the motion for new trial that you just filed, I was actually shocked by some of the facts that came out in that motion. And I think that if I was shocked, the public will be really surprised. Why don't you tell us some of those facts that never came out at trial?
Well, some of those facts were some of the trial witnesses that the state put on to testify had not only sent similar emails to underage girls to the same thing that Owen Labrie was convicted of for the felony, and they were not questioned about that. The state knew that when they brought these boys in to question them. And these boys came in with attorneys with agreements that they're not going to be prosecuted. They're not being looked at for criminal action. And that was not brought out at trial to question them. One of the things that was not brought out at trial regarding the complaining witness was, as I put in the motion, she testified, I was very sore, I couldn't walk downstairs, I couldn't sit on a wooden floor, I couldn't cross my legs, I was so sore from what she alleges happened. And in reviewing discovery materials, we find a picture of her jumping on a trampoline doing splits the very next day.
The next day after this supposedly happened?
Correct.
And that never came out in
Never
trial?
came out of trial.
What about the whole idea of discovery of social media involving all of these young people? That a lot of that did not come out at trial.
Right. A lot of what was, I mean, let me go back. Pre-trial, Owen had asked his defense counsel to obtain the social media records of the complaining witness, thinking that's typically how students were communicating in the St. Paul's campus. I mean, it was more common than picking up a phone, was just going to Facebook and sending messages via Facebook to each other. And then, so those records were not obtained. But we do know from the records that were obtained that what prompted the report in the first place was actually a posting on social media. It was a posting on a picture of the complaining witness and her sister, and a comment someone had posted on that picture that had prompted the complaining witness to become upset and allege that Owen had assaulted her.
Jay, before we let you go, let me just ask you, what happens if the motion moves forward and what happens if it doesn't?
If the motion moves forward, the state will have a time to respond, and then the court most likely will give us a hearing, although they don't have to, and then we'll have an evidentiary hearing on maybe the court might want to hear from some of these potential witnesses who were not called. If the Supreme Court doesn't stay our direct appeal, then that may have to wait while we go to the Supreme Court and litigate our direct appeal and then litigate it after.
All right, CBS News analyst Rikki Klieman, we thank you, and attorney Jay Rancourt, thank you both for being with us. Appreciate it.
Thank you.